Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Negotiable Instruments Amendment 2nd Ordinance 2015. To discuss the issue, I have with me Mr. Gaurang Kant, Managing Partner, Kant and Associates, and Vinayak Srivastav, Advocate. Now for the headlines. Check bouncing cases will now be filed within the local jurisdiction of the pay's bank branch. Ordinance defines a check in the electric form and authenticates digital signature. All complaints against the same drawer will be filed before the same court. The Negotiable Instruments Amendment 2nd Ordinance clarifies that cases of check bounce will be filed within the local jurisdiction of the pay's bank branch. The ordinance also says that all pending cases as well as filed cases will have to be transferred to the jurisdiction where the incident of bouncing occurred. This clarity does not exist in the present law.
The Supreme Court, in its judgment on the jurisdiction of courts which can try cases of dishonoring of checks, said that it should be done where the bouncing incident takes place. But it also said that only cases where post the summoning and appearance of the alleged accused and the recording of evidence has commenced will continue to be tried wherever they are. All other complaints, including those where the accused has not been properly served, shall be returned to the complainant for filing in the proper court. This part of the order prevented several cases to be transferred to their court of jurisdiction. Following this lacuna in the judgment, representations were made to the government expressing concerns about the wide impact this judgment would have on the business interests, as it will offer undue protection to defaulters at the expense of aggrieved complainant. In order to clarify the confusion, the government opted for an ordinance.
These amendments will affect the legal procedures in a sense that now all the cases under 138, once the ordinance is converted into law or it is repromulgated, all the 138 cases will be filed where the drawee or the payee in whossoever the check has been drawn has his bank, and that court will have the jurisdiction.
The amendments in the ordinance ensure that all the cases which were pending in any courts will have jurisdiction under the new procedure. The cases would include both transferred cases and ongoing filed cases. The bill also defines a check in the electronic form as a check drawn in electronic medium by using any computer resource and signed in a secure system with digital signature and asymmetric crypto system or electronic signature.
Legal procedure, they will not affect much more. All the cases will transfer to the home branch of the court, and this will go very smoothly.
The ordinance is likely to increase the credibility of the check as a financial instrument, as there will be clarity on jurisdictional issue related to check bouncing. It would also allow lending institutions to continue to extend financing to the economy without the fear of loan default on account of bouncing of a check. The Negotiable Instruments Amendment 2nd Ordinance was brought to replace the enforced Negotiable Instruments Amendment Ordinance. The ordinance comes into force from 15 June 2015.
The Negotiable Instrument Amendment Ordinance gives a clear picture on jurisdictional issues related to cases of check bouncing. It defines the place of jurisdiction for trying cases of dishonor of checks. This would result to increase in the credibility of checks. With cameraman Vivek, Dipali Pandit for Rajya Sabha Television.
A negotiable instrument guarantees payment of a specific amount of money on demand or at a set time. Promissory notes, bills of exchange, banknotes and checks are available negotiable instruments. Now my first question is, before we start on the other big issues, is it strengthens the rights of the institutions, the banking institutions. But are there issues for the individual borrower? How is the individual borrower going to get affected by this?
Well, I think it also strengthens the stand of the individual borrower too. Because when the individual borrower is taking the money, now he doesn't really need to go to the place where the person is writing the check to file a case. So I think the ordinance, in a way, is actually strengthening the individual borrower because he has got very limited means. Maybe it would be a little easier for the banking and the institutions to actually go and fight a case anywhere in the country. But when it comes to an individual borrower, he is doing it with a very limited need or means. And that is the reason why he's borrowing the money also. So I think the ordinance in itself has created or made it much more easier for the individual borrowers to go and file a case wherever this is happening. So I think it has helped them.
Your take on it?
Yes, I agree with Mr. Kant that the individual borrowers, it will really help the individual borrowers and the small businessmen. And this ordinance specifically gives an immediate relief to them because of the amount of checks involved in these cases are very low. And so the confusion which was caused after the Supreme Court judgment in cases for the jurisdiction, and it resulted in the increase of legal expenses, legal cost, sometimes more than the legal cost of the check itself. So this has provided an immediate relief to all those small borrowers and the small businessmen.
On the point of payable at par, you were just mentioning to me that there was a Bombay High Court judgment which made the check payable at par anywhere in the country, correct?
That's correct.
Now, what happens to that? What's the implication?
No, even that issue stands settled with the new ordinance because after the Supreme Court judgment of Rathod, what had happened is, we all are aware, and that is the reason why the ordinance has come into place, is that it should not only be filed where the drawer is writing the check, but it can be filed in the place where the drawer is putting the check to. And the Bombay High Court had created a sort of a niche or a separate thing from the Supreme Court judgment where they said that payable at par would mean that the person could go to any of the branch and could file a case. Though they went up till the Supreme Court, but then they had withdrawn the case, so the Bombay High Court judgment was pretty much active till the time this ordinance came into place. So I think the ordinance has, in a way, settled the entire controversy as far as the jurisdiction of filing of the case is concerned. And I think it's a big step forward as far as the government is concerned because they have been talking about increase in the financial sector, in the sense strengthening of the business in the financial sector. I think it goes a step forward for everyone, from the borrower to the lender to everyone, because we also have to see that they have created certain rights for the lenders too. It is not that it is a one-sided ordinance or law which has come into effect, but I think the government has tried to balance it pretty well.
The negotiable instruments, payable at par, do you see the operation of the negotiable instrument shrinking here after this clarification in the ordinance?
Absolutely, that the jurisdictional issue, now the payable at par, there was a multiple jurisdictional issue in that. And now this jurisdictional issue has now shrinked into a payee's bank account. So it has definitely settled the issue, and it has bring a clarity in law. And now this issue of multiple jurisdiction now doesn't come into play.
So, if I have understood it correctly, is it correct to summarize it as, now the payable at par negotiable instrument, as far as the loan part is concerned, where the payment through negotiable instruments are involved, will jurisdiction-wise will be limited only to the account where the payee presents it or extracts the money?
Absolutely.
Is that the understanding as far in view of the Bombay High Court order? Okay, moving on, next part. Practical difficulties that would incur after this ordinance.
Well, I mean, I can, as a lawyer, I can tell you I'm facing a lot of practical difficulties because whenever we are working with fund houses and they have been, lending money, there are multiple check bouncing cases which we are facing on a daily basis, and we had to move to jurisdictions which were as remote as Tumkur or somewhere, down in south. First of all, you had to find a lawyer over there, you had to, transfer the cases, then the entire process was completely thrown out of the wheels, in the sense it was very difficult to manage it. And again, the difficulty would be to bring back those cases. And again, the time loss which has happened in all this period, as well as the cost which is involved in that. So I think though the ordinance is really very welcoming and, it's a great thing to happen, but then again, at the same time, the time which has been lost and the cost which has been incurred by the financial institutions or the borrowers has been tremendous.
And there is no compensation
There is no
or
compensation.
nothing. So both the parties now will have to start afresh at a completely new
Absolutely.
location.
Absolutely.
And all of them.
Absolutely.
Yeah, Yauti.
Yes, absolutely. In India now, there are a lot of migration happening. Like in big cities, like from small town, people come from small town who has the bank accounts in their small towns.
Correct.
And they receive checks in Delhi or in Bombay. So now these cases will get transferred to all those villages or all to those remote areas in which they are holding a regional bank account. So this will also create a lot of delays. And we know that the structure of courts here in cities is quite different from the structure of courts in the villages or in other small towns.
So, that's a very interesting perspective you've brought. What happens now is, in view of the migration patterns,
Yes.
now the cases that are going to be filed in such matters will be back from where they come from.
Where they come from.
If they don't have an account here.
If they don't have an account here.
So that means the lawyer fraternity. So basically what you see is that the strengthening of such legal fraternity in regional also taking place.
Absolutely.
Is that a possibility? Because there's a limit to what Delhi, Mumbai and the urban centers and their trial courts can hold.
That's true. That's true.
So is that a right way of looking at it?
Well, even when you see most of the bigger companies like Citibank or City Finance, you would see a lot of cases in remote areas. And, I've been working for them, so I know that we have been fighting cases in the remotest of the remote areas. And it becomes actually very challenging to find the right kind of professional help and advice in these places. So I guess the balancing act would also mean that strengthening of the legal profession as far as the lawyers are concerned in the remote areas too.
So this is disruptive. Okay. Time for a short break. Coming up, we will discuss how the amendment could help in clearing up large number of pending cases of check bounce. Welcome back. The government was forced to take the ordinance route as it could not get the bill passed in the parliament. The government has proposed the Negotiable Instruments Amendment Bill 2015, which is pending in the parliament. This bill seeks to address difficulties faced by the payer or the lender of the money. The amendment would help clear large number of stuck cases as the jurisdiction of offence has been clearly defined in the bill.
The amendment defining filing of cases would speed up the lengthy trial procedures and would overcome the legal lacuna. After the bill is passed, the litigation expenses are expected to come down. Also, the drawers of check will be more careful before signing such checks as they would be answerable for their actions. The government feels that these changes in the law will be fair to both the parties.
Payee is a person who is receiving the money. When he is getting the check, it means he has immediately received the money. Who is the defaulter? Defaulter is the person who is issuing the check. If for the fault of the defaulter check has been bounced, why the payee will suffer? So this is fair in both the ways, because the payee will be benefited, because in the changed scenario, the payee can file the cases against the payer in the jurisdiction in where he is residing, where his bank is there.
According to the proposed amendments, all complaints against the same drawer will be filed before the same court. If the payee or the holder of checks in due course files a complaint against the drawer of a check at the local court, or if a case is transferred to the local court, the complaints against the same drawer shall be filed before the same court, irrespective of the fact that the checks were presented for payment within the territorial jurisdiction of the court. In pending court cases where more than one prosecution is filed by the same person against the same drawer, court shall transfer the case to the court having jurisdiction before which the first case was filed.
the jurisdiction which was laid down by the Supreme Court, it helps only the accused. As far as the victims are the persons who in whose favor the check has been drawn. So even if a check is of 50,000 or 80,000, they have to file the case in Andhra Pradesh, being a resident of Delhi. It will be very difficult for them to proceed with the proceedings. So it is, I think, beneficial, very beneficial for the public at large.
The Negotiable Instruments Amendment Bill 2015 was passed in the Lok Sabha on 6th August 2015. The Negotiable Instruments Act 1881 was enacted to define and amend the law relating to promissory notes, bills of exchange and checks. The Banking, Public Financial Institutions and Negotiable Instruments Act 1988, inserted in the Negotiable Instruments Act 1881, is the law in force. This law provides for penalties in cases of dishonor of checks due to insufficiency of funds in the account of the drawer of the check. Due to deficiency in dealing with dishonor of checks, further amendments were carried out in 2002. This was aimed at speedy disposal of cases relating to the offence of dishonor of checks through their summary trial, as well as making them compoundable. Punishment provided was enhanced from 1 year to 2 years.
The government decided to amend the Negotiable Instrument Act to create a suitable legal framework for the determination of place of jurisdiction for trying cases of dishonor of checks. The ordinance comes as a big relief to the sufferers of check bounce cases who have to travel long distance to get justice. With cameraman Vivek, Dipali Pandit for Rajya Sabha Television.
When checks were issued as a negotiable instrument, there was always a possibility of the same being issued without sufficient amount in the account. With a view to protect drawee of the check, a need was felt that dishonoring of the checks be made a punishable offence. My question to you is, litigation expenses will go down.
Yes.
Do you see it happening, or it's the other way around?
Well, if we look at a short-term way, then the litigation expenses will go up because right now there are going to be transfers are going to happen, and the transfer is going to happen in remote cities, or it can happen in a city, in a different city from the drawee might be residing right now. So, in a short-term way, litigation expenses is going to increase. But in a long-term, if you look at a long-term perspective, then it is a good initiative taken by the government, and the litigation expenses will come down because the pendency of the cases will be less, and the cases will come at one jurisdiction rather than in a multiple courts. So the litigation cost in a long term, it will definitely go down.
Do you agree with him?
Well, the litigation...
You want everything to happen in Delhi?
Not really. I don't think so that that's the point. I think it is more to do with the fact that the person should not suffer, whosoever is getting the check, because the check is a promise, that he'll be made the payment. So I think wherever he resides is the place where he should be allowed to file a complaint. And I think as far as the cost is concerned, it will not really go down, because the fact remains that even if all the cases are going to come to Delhi, Delhi is already populated with number of cases, but that doesn't mean that people are going to reduce their fee structure. So I don't think so that it will have any impact as far as the fee structure is concerned. But yes, as far as the cost to the person concerned is there, yes, it will be considerably reduced, because he need not go to a different jurisdiction to file a complaint and to hire a lawyer in that place. So the traveling time, the other cost which is involved in the entire litigation, that might get reduced. So that will be beneficial.
As far as the lawyer perspective is concerned,
Yes.
how does it benefit the lawyers who've been handling such cases? How does it benefit the ones who will probably be entering into this system for the first time? And who will lose out? Which lawyers will lose out?
Well, I think this is a summary trial, and that is exactly what it is supposed to be. So as far as the competency of the lawyer is concerned, or how it is going to benefit the lawyer in terms of enhancement in the legal profession, that is not something which we really need to look into, because summary trial would mean that the court is already going with a prejudice that the person who has issued the check has actually taken or owes the money to the borrower. So I think the entire concept would be more in terms of the judge looking into the fact that whether the person actually owes or not. So the competency and the skill and the other aspects of the lawyer, in a proceeding like this, you don't really get to show that kind of competency too much. It's not really a full-blown trial what we are seeing. It is a summary trial. It gets reduced.
On the point of, you wanted to add something?
Absolutely, it's a summary trial, but competency of a lawyer is tested in this cases also, because it is not a clear-cut cases. Normally, it's not a clear-cut cases because the checks are sometimes given as a security, and sometimes a blank checks have been given to the other party.
Correct.
So there is a lot need to be proved in these checks, in these cases, in 138 cases. So competency of a lawyer is definitely a very essential element in these cases.
Lawyers are always competent. They're supposed to be competent.
Correct. Now, as far as this settles the law,
Yes.
now when lawyers and legal fraternity uses the word settles the law, how do we understand that? How would you like to, explain that this ordinance settles the law?
See, under the Indian Constitution, Parliament is the supreme body. So, if any is promulgated, ordinance is promulgated, and it becomes law, then it is a final law. And so,
in view of the negotiable instruments,
yes,
what is it that is settled here in this? Although we've discussed all that, but I still want to go back to it. How do you think the law has been settled by this ordinance?
there has been divergent judicial opinions in regard to the jurisdiction of the court. And sometimes it says the drawers, and sometimes it says where the offence is committed. And now this ordinance has completely settled this issue once and for all. And the jurisdiction now will lie only at the payee's bank account. That is the simple understanding of this.
You want to add to that?
Well, I just want to add one point to it, that the distinction which was carved out by the Bombay High Court as well as the Supreme Court, there was sort of a confusion in there,
Yes.
which has again been taken care of by this ordinance. And what he says is correct to the extent that even as far as the territorial jurisdiction aspect is concerned, the entire controversy has been put to rest with this ordinance.
Ease of doing business. Now,
Yes.
that's the larger implication which people like to talk about. How is it going to improve or enhance the ease of business?
This new government, Mr. Modi's government, has taken initiatives in regard to doing ease of business, and it has taken a lot of initiatives in other sectors also. And
How does this ease the business?
this ease the business. This will increase the investors' confidence in investing in India. The major concern for every investor, foreign investor, is the judicial structure of this country and basically the judicial pendency of the cases. And so this will basically boost their confidence in investing in India, and this will help them, catch the defaulter in a better way. So, yeah.
Specifically, ease of business.
Well, I think he's correct to the point that it is going to enhance the confidence level of investors into India, and we see more and more fund houses coming into India. We see more and more, lending houses being here in India, and I think the difficulty which they were facing because of this controversy or because of this Supreme Court judgment as well as the Bombay High Court judgment, all that gets to rest, and with this ordinance, I think the government makes it much easier for the lenders and people who are coming into India to do business.
So there's no ambiguity. It is absolutely clear.
It is absolutely
If you are getting in, this is the risk and this is what you'll have to spend
Absolutely.
in order to salvage the
Absolutely.
risk.
Absolutely.
And that's it. Plain simple.
Absolutely.
Moving on, my colleague Deepali Pandit spoke to Mr. Rahul Dhawan, managing partner, Lex Chambers, to get his point of view.
Sir, how would these amendments affect legal procedures?
The basic difference from what the law previously was and what this ordinance brings in is the fact that the previous law suggested that the payer's bank of place will be the jurisdiction where the proceedings will lie. With the current ordinance and how it has been interpreted, and I think it's a very good step, keeping in mind the intention of the legislature and also the intent of the act, is that the payee's bank of place will be the place where the jurisdiction will be. So to say that if there are two parties, a check is issued from a party from Hyderabad to a party in Delhi, in case of a dishonor of check, the party at Delhi will be able to file a proceedings in Delhi itself, being the recipient of the check in here and his place of bank being in Delhi itself.
So do you think these amendments would strengthen the Parent Act?
Definitely it will strengthen the Parent Act, because the intent of the Act is to ensure that all financial transactions are done in clear and crisp way, which is by way of check, and white payments are made. This particular amendment is only going to strengthen the Act further.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.